Yeah, good morning, everyone. So, I'm Professor Vivek Joshi, working as an SSIP coordinator of RNG Patel Institute of Technology. Heartily welcomes you all for a webinar on an overview of the basics of patent. So, today we have Latika Khanduja, ma'am. So, ma'am, on behalf of RNG Patel Institute of Technology, I heartily welcome you. So, ma'am has completed her Bachelor of Engineering in Electronics and Instrumentation from the North Cap University. Also, ma'am is a registered patent agent and currently pursuing LL.B from CCS University. Madam is a founder and director of IPLOEA company. I think, if I'm not wrong, it's IPLOE, right, ma'am?
I IPLOEA. Yeah.
Yeah, IPLOEA, right. Thank you very much, ma'am. And madam is a very have a madam has a huge experience related to filing a patent and startup related the concept which is recently introduced by government of India, and India is right now keen to work towards this specific things, right? So once again, on behalf of RNGPIT, ma'am, I heartily welcome you and thank you very much for sparing a time for us. So now I hand over the session to Latika, ma'am. Uh, so I request
Thank
ma'am to please share your screen and we can have a discussion related to the importance of IPR and how this will be helpful for the students and how we can process for patent in India. Thanks a lot, ma'am.
Thank you so much, Professor Vivek, for introducing me, and I welcome all to today's webinar. I hope my screen is visible,
Yes, ma'am.
and
Your screen is visible. Yeah.
great. Thank you so much. So let's begin with today's presentation. So we'll discuss the agenda that what we are going to discuss today. So we are going to discuss what are patents, why do you need patents, and what is the process of filing the patent, and how can we help you in that, and how the patents are different from other IPR forms, that is trademarks, copyright, design, and so on. So let's begin with that. And before we discuss about patents, I would like to introduce myself and my firm. So I'm a registered Indian patent agent, as mentioned by Professor Vivek as well. I have more than 10 years of experience in IP industry. I have worked with world's largest IP service provider, and this year I have founded my own firm, and through my firm we provide end-to-end IP support to students, startups, MSMEs, and of course, big corporates. And we do provide services with respect to patents, trademark, design, and copyright. And we cover almost all the technologies, that is, high tech, mechanical, biomed technologies. And so before we, jump onto the boring part of the presentation, I would like to take 2 minutes of your time and discuss about a very interesting man here. That's Dr. Michael Doyle. I believe that most of you are not aware of this person, and that's why I really want to take this opportunity to talk about this person. So, who was he? He was a researcher or inventor like you and me in the University of California. Okay. And what he did, he actually invented a web browser that supported plugins, streaming medias, and cloud computing in 1990s, right? And he was intelligent enough and he was aware of patents, and that's why he filed patent application on his invention, right? And you know what happened next? He found that Microsoft, one of the biggest companies in the world, its Internet Explorer is infringing its patent. So basically, Internet Explorer was using a technology which was present in the patent that is protected by Dr. Michael Duell. And that's why Michael Duell, he reached out to Microsoft for licensing, but Microsoft denied, because it was a very big company, and that's why he denied. And that's why Dr. Michael Duell reached out to US court and filed suit against Microsoft and of course other companies, but here we are specifically talking about Microsoft. and in return, he was awarded damages of $521 million. That's the power of patents. So as you can see that, he could have spent time on, improvising his technology, make sure that, it is user friendly, and working on that all the time. But he actually took out time, and he was actually aware that, what all I mean, how I can be benefit from patents, and that's why he filed patents on this. Otherwise, if he could have just worked on his technology, he might not have, earned so much of money out of it. So the next Michael Doyle could be you, but only and only if you actually take out time to protect your idea now. Because if somebody else does it, then you will lose out the opportunity to get a patent on your idea, and somebody else will obviously do it. Yeah. So let's talk about, what are patents, because it is very important to understand what exactly can be protected. So first we'll look at, definition of patent. So basically, it's a legal right that is given to a person over the creation of his or her mind. And what is it used for? It is used for preventing others from making, using, offering for sale, selling, or importing the invention. So I'll give you a very small example here. So let's say, if you build a house, then what do? I mean, you want to make sure that, that property belongs to you, and you want to make sure that nobody else can use it or do anything without your permission, right? So what do? You actually create a boundary by means of fences or something like that, right? To protect and to say that, this is my home, and you are not supposed to do anything without my permission, right? Similarly, patents are also used for creating boundary around your invention, to say that, this is my invention. Nobody is supposed to do anything, make it, make similar thing and sell it or do anything about it without taking permission or license from me, right? So this is why patents are used. I hope I have cleared it, but I will give some more examples so that, things are clear. So some of the examples could be, a recommendation engine which recommends similar products to a user. That can be on the basis of anything. I mean, any parameter. It can be on the basis of user history, on the basis of location of the user, or how many times he has actually clicked on a particular product, age, and anything, right? It can be a recommendation engine which recommends that, if you want to go from place A to place B, then take this route, take this first route instead of second route, something like that. It can be a recommendation engine that can also recommend nearby restaurants to you based on your personalization. Another example could be, say, social media that provide ads based on user profile. And it can be on autonomous vehicle. Nowadays it's lot of it is in news. And it can be on a web camera, it can be on the application that is running on the phone, it can be on the measuring tool. So these are some of the examples that can be patented. I hope I have cleared some of the doubts. But first, let's see, why do we need to register a patent? We have talked about a few points in the previous slides, but now I would like to, talk about those features again, and also new aspects, to make sure that, you understand the importance of patents. So as I mentioned earlier, that, it is used for stopping anyone from copying your idea. Okay. So because this is your invention, you have put your hard work in that. Nobody is supposed to steal your idea or copy your idea without, giving any royalty to you, right? And another reason could be, as we have seen in case of Dr. Michael Joel, that, he actually got such a huge amount from this. So similarly, you can also treat it as a source of revenue, if by, if you want to go for license, or if you can also see if somebody is infringing, and you can also file a lawsuit against that person. Another reason or advantage is that patents actually help in gaining marketing edge and credibility. So you might have seen a lot of FMCG products. If you see at the back side, you can actually see that they write patent number on their product. Why do they do that? Because that's the they want to gain marketing edge over it. They want to say that this is my invention, and which is novel and protected by means of patents. They can also, I mean, they are also using other tags as well. So for example, patent pending. So whenever they apply for the patent, they also write that patent pending. So this is just for gaining marketing edge and show that this is a credible product. Another advantage is that it increases valuation of your company. So I was in discussion with lots of startups, and one of the main reasons for filing the patents is that they actually increase their valuation of their company. It can be two times, three times, or 10 times. I mean, that depends upon a lot of things. And in most of the cases, whenever they reach out to any investors for funding, then most common question that they face is is your idea protected? Because they also want to invest in a company in which the idea is protected and strong enough, right? And they really want to invest in that company in which they can see that no other company can come because our idea is protected in this domain. Yeah, moving on. So, what do you have to do when you have an idea? Okay. So, first of all, let's say whenever you have any idea, reach out to an expert patent firm like me for guidance. Okay. And make sure, I mean, this is very important for you to understand, that make sure you do not disclose your idea in public. So that means you should not publish your idea on a website or any other social platform media like LinkedIn or something like that. Because if you disclose your idea in public, then you won't be able to get a patent on that. So this is very, very important. And whenever you reach out to expert patent firm, make sure that you sign an NDA before discussing your idea, because it is your invention, and other person is not supposed to leak out your information, right? Because that's confidential. That's why non-disclosure agreement is very much required here. Another thing is that you have to decide in which countries you want to patent your idea. So in that case, patents are territorial. So if you want to take protection in India, you have to file patent in India. Okay. And if you want to take protection in US as well, you have to file in US as well. Okay. It's not that you file the patent application in India and you are getting protection worldwide. It is not the case. You have to reach out to different countries individually, and then you can actually get the protection in other countries as well. So moving on, so whenever you reach out to patent firm, so what they generally propose as next steps. So they can actually assist in checking whether the idea is patentable or not. So this means that a patent is granted for only those inventions which are new and which are not obvious. Okay. I mean, not obvious means that it should not happen that from one application you are taking out one feature, and from another application you are taking out another feature, and you are simply aggregating those two features. Because in that case, the examiner would say that this is not new. I mean, you have simply aggregating the two existing features in one application, right? So in this particular step, we actually conduct a search. Okay. To confirm whether your idea is actually new or not. So that's a preliminary search that is done. And after that, we may propose to say that you may apply for a provisional or non-provisional patent application. So let's talk about these patent application in detail in subsequent slides. So, what are provisional applications? So, as you can see, I mean, as the name suggests, that's a provisional. or that's a preliminary or intermediary patent application that is filed only and only when your invention is still evolving, when you believe that you need some more time to completely evolve your invention, to thought through all these things. But the basic idea that you have can be protected at first place, because if anybody else can will file a patent after, let's say you file a provisional application today, okay, where you will protect your basic, where you will write the basic idea that you have, and somebody else after 2 months file a patent application on the same aspect, then you are safe because you have actually protected your basic idea, and on the basic idea he won't be able to get patent on it. Of course, protection is given only to the content that you have mentioned in the provisional application. So it is, so for example, uh, so I'm talking about provisional. I hope you have to be clear with that aspect. So let's say, in the provisional application you write 5 features, okay, and in the non-provisional application you are planning to have total of 8 features, okay. So the provisional and in between somebody else file a patent application which contains features 6, 7, and 8, okay, which was not there in the provisional application. On those features you won't be able to get benefit from the provisional application, because those 6, 7, and 8 feature were not present in the provisional application, right? So whatever you have mentioned in the provisional application, that content is secured, okay. And as I have mentioned that it is just a placeholder for getting a benefit of priority date. And if you go with the provisional application, you have to file the complete or the non provisional patent application within 12 months, okay. If you do not do that, then your provisional application will be abandoned. And the provisional application is a low cost and less formality requirements are there, and this is completely optional. You can directly, go with the non provisional application if your invention is ready. So let's talk about non-provisional application. So as I mentioned that you can say that it's a formal or regular patent application that needs to be filed within 12 months if you are starting with the provisional one. And otherwise, if you do not file within 12 months, you will the provisional application will be abandoned, okay. And if your invention is complete, it is advisable that you go and directly file the non-provisional application. And the legal rights that you will get, okay, that is based on what is mentioned in the non-provisional application, because the provisional application is never published. It is not published until the non-provisional application is filed, and it is not even examined. So the legal rights you will get is based on the non-provisional application. I hope it is clear. Let's move on and learn the process of obtaining a patent. The first step, which is completely optional, as I've mentioned earlier also, that we are determining the patentability of your invention. So, in this particular case, in order to make sure that in order to evaluate whether the your product is new or not, or the process is new or not, patentability search is performed worldwide to see if somebody else has already published or patented the idea that you are putting in the application, okay. So this search should be done worldwide and not just India. So let's say if somebody else has published or protected this your idea in US, then you won't be able to get your patent. Examiner won't grant your patent application because it is already done by somebody else, and he will say that this is already there, you have not done anything new. Yeah. So moving on to the next step, which is drafting and filing a patent application. So patent is a techno legal document, okay, it needs legal as well as technical expertise to draft patent application. So even you can also draft patent application by your own. However, you might only have, technical expertise. Of course, you are the technical expert. That's why you got the idea, right? However, you might not be having legal expertise, and that's why, you might not be able to cover a scope which is broad enough, right? So as I've given the example of, protecting your house by, making a boundary. If you create a small boundary, then, you will have less legal rights, right? If you just um, have more boundary, then of course you will have more area, right? You will have legal rights on the more area. So that's where, the scope is very very important. And that's why, for drafting a patent application, it is recommended to get professional help from patent agent or attorney, which is who is expert in this field, right? And let's say, the even if a low quality patent application is granted, if the scope is very narrow, even if it is granted, then it would be of no value because the scope is very narrow and there is no commercial value as such. Okay. And the grant of a patent, it depends upon, quality of the invention as well as quality of the patent application. So that's why, the quality of patent application is very very important for each and every aspect. Okay. So moving on to the third step, once the non-provisional patent application is filed, I'm talking about non-provisional patent application here and not the provisional one. So once it is filed, the application is usually published after 18 months from the date of filing the non-provisional patent application. So until then, the patent is kept secret, the application is kept secret by the patent office, and nobody can see it. Only after 18 months, once it is published, it will enter the public domain. And if you want, you can also expedite this process, but you have to file a request for early publication by paying extra government fees. Yeah. Moving on to the next step. So as till now we have learned that, the first you have to uh, draft and file the patent application, and then it will be published, and then the next step is the examination stage. Okay. So during this stage, examiner would look at the patent application and see whether all the criterias for, patentability are fulfilled or not. Okay. So he will see whether this invention is new or not, whether it is obvious or not, whether it is clear or not, and, there can be ample number of things that he will check. Okay. And examiner may give various objections and rejection in the examination report. And this is very common. I mean, in most of the cases it will come, because whenever we draft the patent application, we try to ensure that, we capture the broader aspect. But, the examiner would come up and say that the scope is very broad, you have to narrow it down. So in that particular case, we may have to argue with the examiner, or we may have to amend the patent application. So that depends upon case to case, right? So moving on, whenever, you see a examination report, then we have to respond to the examination report. Okay. And the examiner will give, I'm saying that again, that, in most of the cases you will get such examination report, and we don't have to panic on that part, right? And once we receive the examination report, we need to reply within a specific time period. Okay. So we have to address each and every aspect, each and every objection or rejection that the examiner has raised by replying to the examination report. And examiner may also give a notice of hearing as well. So, you know there can be multiple reports and multiple hearings as well. So, this is just to make sure that everything is clear. And once each and every aspect, I mean, each and every objection and rejection is clear, then your patent will be granted. and now you can enjoy your exclusive rights to prevent or stop others from, commercially exploiting the patented invention. Okay. Okay, so let's talk about, let's just summarize what we have learned, and let's see the timelines again. So this is a summary of this. So let's say, you begin with the filing of provisional application, which is completely optional. I'm saying again and again because this is only, we generally go for this route only when the invention is still evolving. Okay. So once, let's say, you file the we go for the provisional patent application, you have 12 months of time period to file a non-provisional application. If you do not file the non-provisional application within 12 months, the provisional application will be abandoned. Okay. Once you file the non-provisional application here, right, then it will be published after 18 months. So this is the publication, and as I've mentioned earlier, that it can be expedited also. Once it is published, then it will enter the queue for examination. And the examination in this period, the examiner would look at the patent application and see whether all the criterias are fulfilled or not. Okay. And after addressing all the objections and rejections, the patent application will be granted at this stage. One thing that I would like to say here is that, if the examiner believes that the invention is not new, and he found, certain arts that are talking about your invention, then he can also refuse the patent application. And in general, the time taken from filing the non-provisional patent application to grant of the patent application is 2 to 5 years. It can be less, of course, if you expedite the process by paying extra fees, or it can be more than 5 years as well. That depends, but it's very rare now. Nowadays, you're getting, we are receiving a very fast examination, and everything is very, very smooth now. But that depends on a lot of cases. It depends upon how many attritions are going on with the examiner. It depends upon the backlog of the Indian Patent Office, and so on, right? And after the grant of the patent, the patent would expire from 20 years from the day of filing, right? So you can the patent is valid for 20 years. After that, it is not possible to renew it or do anything about it. Once it is expired, it is expired. Okay. And during these 20 years, you have to pay maintenance fees as well, which is, very less. So for startups or individuals, it is only for first to 4 to 5 years, it is only 800 rupees per annum, but gradually it will increase year by year. I hope things are clear right now, till now. Okay, so how can we help you in getting a patent? So we will help you in each and every stage. So we in at the very beginning, we will provide free consultancy, ideation and innovation consultancy to you to understand your idea and share whether it can be actually patented or not. Okay. So whenever whatever queries that you have with respect to patterns, we can of course provide you free consultancy in that. After that, we will also help you in conducting a patentability search, where we will see, where we will conduct a search on the paid databases to confirm if this idea is already published or protected by someone else in the world or not. And then we will definitely draft the patent application, and will make sure that the scope is broad enough so that the commercial value of that patent is really good. And once we draft it, we will file in the respective patent office. So if you believe that you want to protect your invention in India, we will file the patent application in India. If you want to protect in US, we will file the patent application in US as well. Okay. And we will also support in patent examination stage as well, and the prosecution stage, where we will deal with the examiner. We will communicate with the examiner, we will attend the hearings as well, in order to make sure that you will get grant on the patent. Yeah. Okay, moving on. So there are some categories, which cannot be patented in India. I mean, the list is, I mean, I have extracted few points. Not, this is not comprehensive or exhaustive, but I've listed few points that I would like to discuss. So the first is, any invention which is frivolous or against natural laws, that cannot be patented. Inventions that are contrary to morality, if anything is, uh, harmful to human beings or animals or anyone, right, then you won't be able to get a patent on that. Discovery of a scientific principle, so let's say you're just coming up with a theory, okay, then you won't be able to get a patent on this, because patent is granted for new product or process. Okay, so theory is not even a product or not a process as such. Okay, because process has also, I mean, we have to tie that with the apparatus as well. And the discovery of living or non-living thing is also not patentable, because you have just discovered it, right? There is no innovation as such. And agriculture or horticulture method, so the method as such cannot be protected for agriculture or horticulture. But yes, definitely, if you have new equipment for doing the agriculture, that can definitely be protected under patents, right? Moving on to more uh, categories. So let's say new form, property, or use of a non-substance cannot be protected. So I'll give you a very simple example. Let's say, if there is a known substance like turmeric, right? If you found a new use of it, that you can also use it for doing this and this as well, that part cannot be protected in India. Okay, so the traditional knowledge, or aggregation of traditional knowledge, that cannot be patented in India. So mere admixture, mere rearrangement of devices, all these things are not patentable in India. Plants and animals per se, they are not patentable. Process of therapeutic treatment is also not patentable in India. So I have covered almost all the aspects of patents here. Let's discuss other forms of IPRs, and let's try to understand how they are different from patents. Okay. So we'll begin with trademark. So what is a trademark? So I mean, most of you are aware of this, but I would like to take this opportunity to talk about this again. So trademark is a sign, logo, tagline, expression that distinguishes goods or services. And what is it used for? It is used for protecting brand of a company. So you must be drinking soft drinks. So whenever you go and buy these soft drink, what you say, I want Coca Cola, let's say. Okay, so this Coca Cola, that's a trademark of the company. And if anybody else, it's everything is protected. So the background color is red, white, and written in this particular fashion. And I mean, everything that you can see, the all expression, everything is protected by Coca-Cola, right? So, if any other uh, company, like a soft drink company, cannot sell or cannot manufacture under the name of Coca-Cola until and unless he get a license from Coca-Cola company, right? So that's where we have to protect brand of a company, because otherwise any soft drink company can start manufacturing and selling Coca-Cola by their own name, right? They don't need anything. I mean, they don't have to go and license it, and nothing could be done, right? So this is also used for advertising their product or services, right? And this is basically distinguishes goods or services. So as you can see that you have Coca-Cola, you have Pepsi, right? So this distinguishes your goods or services, that this is Coca-Cola, this is like this, and you have Pepsi, this is a different soft drink company that is providing Pepsi, right? So this is all about trademark. Let's move on to very important IPR form, copyright. And most of you are having confusion that I mean, how the patents and copyrights are different. So let's talk about the copyright in general, and then we will talk about how the copyright is different from patents. Okay. So, what is copyright? So, copyright in general, you can say that protects authors' works such as books, poems, plays, songs, films, and artwork. And what is it used for? It is used to stop others from using, copying the author's work, right? So, now we will see that how it is different from patent. So I'll take the example that I've talked about, in the previous slides. That let's say you have a recommendation. You might be using Amazon nowadays. Okay, you can see that there is a section which says that these particular products are recommended for you. Okay, so there might be particular algorithm, right? The codes and everything that would run to give you that recommendation. Okay, that particular algorithm is protected under copyright. However, the complete idea that on what parameters and what scores the recommendation would be given, that part would be covered under patents. Okay, so the idea, complete idea, is protected under patents. The exact source code, okay, or the coding, whatever you have written, that can be protected under copyright. But I would say that patents generally have broader scope as compared to copyright. Why? Because if, let's say, you only protect your algorithm under copyrights, then anybody else, right, can actually manipulate the code, okay, and get the same result by doing the same process. Just by manipulating some code, he can actually do it, right? However, if you have protected your idea under patents, and you have mentioned that I am recommending based on so and so parameters and this particular fashion, then that person cannot even create another, you can say, code or algorithm for achieving the same thing by using the same parameters, right? And that's why the scope of patents is broad. I hope it is clear now. Okay, let's talk about another form of IP, that's design. So, what is a design? So, I mean, design actually protects appearance or ornamental features of a product. And what is it used for? It is used for preventing others from making, using, offering for sale, selling, or importing the product. Okay, so let's understand this in detail. So let's say you come up with a web camera. Okay, that has specific or new functionalities, as well as you come up with a new design that this is easy to handle or something like that. The functionalities can be protected under patents, right? And the design of the web camera can be protected under design registration. Okay, and I'll give you a more generic example, or specific that you might see in your day-to-day basis. You might be using or have seen Apple iPhone, right? So they have actually protected their home button, the design of the home button, that if this is my phone, and at the downside I will have a home button that is circular in shape. Okay, so that particular part is actually protected by Apple, and that's why no other companies, uh, it can be Samsung or any other phone manufacturer, can have the same design, that is circular home button at the downside, cannot be manufactured or cannot be used by any other company. Okay, I hope this is clear. So the design thing is covered under different aspects in different countries. So this in US, this design is considered under design patents in US, but in India it is considered under design registration, but the protection is same. I mean, you are actually protecting the design of your product. Okay, I hope this is clear. So I have covered each and every aspect. Thank you so much for joining today's session and for your time. And if you want to know more about patents, I would request you to please follow IPLOEA on LinkedIn, because I usually post weekly videos, very easy to understand videos on LinkedIn on weekly basis, and you can learn more about it because it is very important, as I have mentioned in my uh, overall presentation. And you can also visit the website www.iploya.com in order to understand more about IP. You can contact me directly if you have any query on IP matters at latika.khanduja at iploya.com, or info@iploya.com. I would be happy to address any query. You can also call me directly at 9811 and I will be happy to give you, help you in all the queries that you will have. Thank you so much for joining today's session.
Yeah,
Over to
so
you, sir.
thank you very much, madam. Right.
Thank you, sir.
So generally, apart from academic, right? So when our students do a final year project, so major emphasis will be on research paper, right? So how you can differentiate research paper and this patent,
So in that case, sir, research paper, I mean, if you want legal rights on your invention, then
right?
we have to go for patents. And I mean, in I would say that, before we actually go for writing a research paper, we should actually protect your invention through patents. I mean, it's not that, if you have disclosed your idea in a research paper, then you won't be able to get a patent. But in most of the cases, I mean, there are some exceptions, uh, and only to that part, you can apply for a patent after publishing your idea on the research paper. So we have to see that, what I mean, why and where and in which cases you have actually published the document. But in general, it is recommended that, you file the patent application before you file the paper, research paper.
Right, right. Thank you, ma'am. So, once again, thank you very much for your precious time. And if I will receive any more queries through from student, I will definitely pass it to you through mail or through message. Right. So, once again, on behalf of R&D Patel Institute of Technology, I thank you for your precious time, and definitely whatever knowledge you have shared will be helpful for your student. So thank you. Thanks a lot once again. Thank you.
Thank you so much. And if you have any query, then you can also directly reach out to me, or you can
Yeah,
also send me email. Yeah.
sure, sure.